Hello, everybody. This is Ian Williams with the Foreign Press Association in our regular podcast series. Well, more not as regular as it should be, perhaps, but our frequent podcast series, Outside In, in which we look at key matters that will be of interest to an international and domestic audience. And in this case, we're speaking to Tom Moore from the Center for American Progress, who has produced some interesting work that's being studied in various state capitals about how to defeat Citizens United. Um, perhaps since we're dealing with people who are not familiar with the Supreme Court, Tom, could you explain what Citizens United is, why it's important, and what you're doing to combat it, as Horatio on the bridge or whatever?
Sure, absolutely. Thanks so much for having me, and I'm happy to be able to explain it. Citizens United is a case by the United States Supreme Court from 2010, 16 years ago, that basically said that the right of corporations to spend independently in politics could not be infringed. And what that means is if you've got a some kind of committee or some kind of group that is spending money in politics but not talking to the candidate at all, then you can't possibly be corrupting that candidate because you're not talking to them and you're not buying any influence with them. Therefore, uh, any money you want to spend can't be limited in any way, because the only way that we can limit campaign spending is if we're trying to get rid of corruption or get rid of the appearance of corruption. And this can't possibly be corrupting, and it can't even possibly create the appearance of corruption. Um, that is obviously ridiculously wrong,
And
factually,
has been the
just in the
source of
real
much
world.
corruption ever since.
It has indeed. But as a matter of law, independent spending in America cannot cause corruption. So those are the legal facts on the ground, and that's what people have been having to deal with for the last 16 years. And what it led to was other cases that created these super PACs that have an unlimited amount of money coming in and an unlimited amount of money going out. And uh, and also these dark money groups that were initially set up to do social welfare stuff, do lobbying and education and other things like that, but not campaign spending. It allows them to do campaign spending, but they don't have to disclose their donors. And so these dark money groups get a huge amount of money from folks who don't want to disclose their names. These groups give the money to the super PACs. Super PAC does have to disclose where it gets the money, but all it ever discloses is the name of this dark money group. And that combination has really done in any kind of meaningful disclosure in American politics. The amount of dark and corporate money that has been flowing through our system since 2010, since Citizens United was decided, is just overwhelmed everything else in the system.
I think that
And
one of the things to remind people from historically is that this decision came after a decades-long fight to limit political spending. So this was
that's
a
right.
complete, this wasn't just an innovation, this was a complete reversal of previous progress.
It had been some time coming. There had been a long time legal project by conservatives to get corporations more into the political process, and the case that kind of set the stage for this, Buckley v. Vallejo, was from 1976, so 50 years ago. And in some ways, these other cases that allowed corporations to do spending in ballot issues, and then Citizens United allowed them to do it in candidate elections, kind of did all flow from that. And there was this kind of long, decades long program to try to get the law to move in that direction.
Once again, just to put it in perspective, because all of this hangs on a very obscure 19th century decision, much contested because it seemed to have been scribbled in shorthand on the back of a piece of blotting paper, that corporations are individuals, that they have a personality, which partly rooted in old Anglo-Saxon law, a corporation. But I think it brings it to what you're talking about. Corporations in Britain used to be chartered by the Crown. New Jersey and other places were set up by corporations that the king gave a charter
Right,
to say you are a very special case and you can do this as long as you pay me. It
right,
was
right.
it wasn't you didn't just go down to your town hall and say I'm setting up a corporation to go to set up the East India Company. You couldn't register at Company's House. You had to get a royal charter to do it with exemptions
Right.
and powers, which I think is where you're coming on to.
Yes. The when that whole scheme kind of moved over to America in the 18th and 19th centuries, it's the same kind of thing where basically the federal government isn't in the business of doing this. It's states that are in the business of creating kind of regular business corporations and charities and nonprofits and that kind of thing. And throughout the 19th century, if you wanted to start a corporation, you had to go to your legislature and say, like, hey, please pass a private bill, have the governor sign it, and go through all the motions so that I can have this charter to run my business. And those charters were very specific. You can be a railroad. You can be around for 20 years. You can, it's very, very specific things, a set list of powers. And if you went past those powers, it was very bad news. Like that, the worst thing a corporation could do would be to go beyond the powers that were granted to it by the state. And it turns out through the 19th century that was incredibly inefficient. Something like half the workload of state legislatures was issuing these private bills. And also super corrupt. Basically whoever walked in with the biggest bag of cash got the charter. And so toward the end of the 19th century, states cleaned this up and they said, like, nope, we're going to do these general charters. You can just walk in, pay a fee, get the charter, do what you want. It's fine. And in the beginning of the 20th century, they started to compete with each other for getting this business, because if you had the charter, if you chartered the business, they would have to pay fees and some taxes to you and that kind of thing. And so they all started competing with each other. And finally, New Jersey said, we're just going to give them everything. You can do everything that's legal. You can do everything a human can do. That's it. And then all the other states are like, oh, and they all matched that. And that's where it has stood for the last 100 years. But there's a feature in every state's law that says, by the way, we can modify your powers or take them all away or do you in altogether at any time. We can just delete this whole section of our code. And you can't complain about it in any way. And it affects not just new corporations, but every corporation that's out there. And any other corporation that wants to do business in our state can't exercise any power that we don't give to our domestic corporations. And those three things working together are a solution to the Citizens United problem, because there's an Achilles heel in the Citizens United decision. They looked at a corporation that had been given the power to do everything that a human could do. And they said, well, in the background, kind of, they made the assumptions like, well, humans can spend in politics, therefore these corporations must have the power to spend in politics. So let's talk about their right to spend in politics. And that's where the decision started. But they never said that a state has to give its corporations the power to spend in politics. And they just assumed that they had given them all these powers, then given these general grants of powers, and that they would never change them. But there's also 200 years worth of Supreme Court jurisprudence that says states have full authority to change it whenever they want.
And the
that's what's
people
happening.
who support states' rights are the ones who are pushing the powers of corporations. So we have an exquisite
There's a little
dilemma.
bit of internal conflict here, yes, which we're counting on.
Yeah, but there's also an angle to this, and I don't know whether it's been used politically. Is that puts corporations? If I commit murder, if I'm responsible for the deaths of thousands of people, if I break the law, I can go to prison. What happens? Can you send a corporation to prison? Can you put a corporation in the electric chair? No one ever seems to work out this corollary in terms of, personhood. Well, okay, which person suffers? Because the directors aren't affected by this. They have complete immunity, shielded by the corporation, don't they?
Right, and that's part of what the state gives a corporation when it creates the corporation, is this limited liability. But it's not something they have to. As a state can absolutely just decide not to grant those powers, and say the power to spend in politics. Just say like, nope, you're not empowered to do that. And if you go beyond this list of powers we gave you, which is now a little bit shorter because this power to spend in politics is no longer there, very, very severe consequences, just like in the 19th century, can follow from that, including the state attorney general yanking your charter, including people's suing directors and officers and executives in their personal capacity for doing things that are beyond the corporation's powers. It's the worst thing a corporation can do under the law is go beyond the powers it's been given. Never mattered much in the last 100 years because they were given the power to do everything. But now states are starting to ratchet that back a little bit, and it's opening up that space for real severe and serious corporate consequences.
Well, you obviously you've done several papers which I understand are being adopted by or examined and or adopted by various states. Can you give us a rundown on which of them are on the cusp about this?
Yes, Hawaii. Last month, the governor signed a bill that would do this, basically
Aloha,
starting
Hawaii.
in. Yeah, they're the our 50th star will light the way for the rest of us. And basically, the law says we will no longer, as of July 1st, 2027, we will no longer extend the power to spend in politics to any corporation that operates in Hawaii. Montana is working, they've been working for a year and a half on a ballot issue, take it directly to the voters. It's amazingly popular there and
Can't think
elsewhere.
why.
Yeah, it's and but they're taking a very, very clean version of this concept to the voters. They're just on the verge of getting enough signatures to put it on the ballot this fall. That should be fine, and I think voters will overwhelmingly vote for it. So by the end of this year, there should be two states that have it on their books. We had 14 other states this year that introduced bills like this, and I've been working with
California is
those
one of
folks
them,
to get
isn't
them
it?
in good shape. I'm sorry.
Is did I see that California was one of those interested?
That's right. I flew out to Sacramento to testify on behalf of the bill there. Um, the other ones didn't get as far, and it's not unusual for a complicated bill, a new kind of bill, to take a couple years to get through. But the best way to pass a bill this year is to have it fail last year. So we're trying to get it out to as many states as possible, and it's been the easiest sales job ever. Basically, people are just picking up the idea themselves and running with it, and we're providing some assistance to help steer the bill in a kind of a legally sound way. But states have just been, people are hungry for this kind of thing.
Well, this is one of the things that struck me right away was that the they're not even the die-hard dinosaurs uh, who you find that their families almost always opposed the New Deal and supported McCarthy. There's a genealogy here, and now sort of that the old money has co-opted the new money in the sense of MAGA, that legislative progress, and they have bodies that have been working on this, like Alex, is it, that have been providing draft legislation, and they have thought this through, but their opponents on the Democratic side haven't. They go state by state or candidate by candidate, and there doesn't seem to be. Well, you're the Center for American Progress, so I hope that you've been working on this counter strategy.
Well, this is my job, and we do a fair amount of that at the Center for American Progress. And there are groups like the American Civil Liberties Union who have had a decades and decades long, program of protecting civil liberties through the courts. Ruth Bader Ginsburg was a ACLU attorney, and Thurgood Marshall was an ACLU attorney, and they did move things forward over decades. But yes, ALEC and other groups like that have had a um, fairly comprehensive legislative campaign that has gone on in many states for many years at this point. And one of the differences between the left and the right in America is that the right does fund that kind of activity more um, um, consistently. They're not always looking for big breakthroughs. They're not looking to win the war this year. They don't mind grinding it out over the next 10
It's a
years.
long
And
march through
that's
the
a difference.
institutions. If we can, they've been doing it for a long time. And what strikes me is there's a clear strategy behind it. Each decision is pushed, or each piece of legislation, knowing that you can build on it.
That's
Whereas
right.
most of the Democrats seem to be very reactive. Oh, well, here's a particular scandal. We'll go. But there doesn't, after the civil rights, there doesn't seem to have been the same momentum to build on the legislative opportunities.
I'm not sure I'd say that's the case all the way across the board. I mean, in terms of like Obamacare and that kind of thing, that was that people had been trying to get that done for quite a while. Um,
Richard Nixon supported it.
well,
He supported national health.
things have changed a little bit since
You don't
Nixon
say.
passed the Clean Water Act and the Clean Air Act.
Uh-huh.
Um, uh, I mean, it's. Um, I think the thought in the community is that funders have slight different tolerances for the long haul. And it's some donors on the right are perfectly willing to fund stuff for 10 or 20 years to get the eventual job done.
Yes, which is disastrous uh, against short-termists who are thinking, well, how can I get myself elected or my friend elected? It's strategic of the kind which you're now coming out with. So, what are there any other initiatives that you have that you care to reveal about
No,
what sort of
I'm going one miracle at a time. But no, it takes a long time uh, get all the wrinkles out of this one. I worked on this one for about a year before or more before we were ready to publicly announce it. I mean, the Center for American Progress is very careful about these things, and so there are other ideas perking, but we'll hang on to them until they're ready.
Well, I've always looked forward to the time when sort of Philip Morris or Monsanto is actually in handcuffs in the dock as a corporation. I'm opposed to the death penalty on principle, but the electric chair for some companies would seem like a good idea.
Well, in Montana, if a corporation who chartered in Montana spends in politics after this law passes there, they could get the corporate death penalty, have their charter yanked. Everybody loses everything. And so there's very good reason that is one of these things where, I don't think with people, the death penalty has much of a deterrent effect. I think with corporations, the death penalty will have quite a deterrent effect.
But how does that play out in the messy federal context? If Montana if Montana says that 3M, for example, a Montana Mining and Minerals Company can't spend on politics in Montana, does that just mean in Montana, or is that corporation entitled to spend like Billy O in New York or New Jersey or Delaware or wherever?
Yeah, so it's they'd be they're a Minnesota company, another M state. So yeah, they could. This is a state by state approach, and whatever Montana does or whatever Hawaii does can only affect activity within Montana or within Hawaii. But if you're a Montana voter, uh, you don't particularly care whether Wyoming cleans up their own elections. You cleaned up yours, and the minute this passes, the minute it's in effect, all dark and corporate money is out of your ballot issues and out of your local, state, and federal elections. Every dollar in Montana politics, once this passes, will be from an individual. It'll be disclosed and it'll be voluntary. And so it does not affect what happens in Minnesota until Minnesota passes it.
So
But
3M can
this
happily spend in other states.
that's right. If you're chartered in Montana, you're out of the business anywhere in the universe. You can't spend in politics. Every other corporation is disempowered from spending in Montana's politics. But which does the trick in Montana. It actually kind of puts a wall up around Montana and says, like, look, this is not something that we allow corporations to do in our state. But if there was any kind of reach outside the state, that would make it unconstitutional. States
But
can't
a
do that.
corporation incorporated in Delaware, for example, is that allowed to spend in Montana?
No, no, because one of the features of Montana's law that's in every state's law says no out-of-state corporation can exercise any power in this state that a domestic corporation can't exercise. So if Montana shortens the power list, or Hawaii has shortened the power list for its own corporations, that has the effect of shortening everybody else's power list as well.
Well,
So
I
it
mean,
keeps everybody out.
one of the counters to this, obviously, Elon Musk is looks beyond the event horizon. They hasn't he Tesla shifted to Texas from Delaware because even the notoriously lax Delaware looked like they were sort of asking questions.
Yeah, Delaware, Texas, and Nevada are in a death race right now to see. They're trying to basically Nevada and Texas are challenging Delaware for supremacy in these registrations, and Texas offered Musk some more favorable terms. And this reform does not deal with that particular thing. And Elon Musk spent north of $250 million on Donald Trump's reelection. That is an individual spending money that got disclosed. It's like, okay, that's this corporate reform can't touch that. There is a bill in Congress that would basically regulate a super PAC like a regular PAC. There is an effort by Professor Larry Lessig of Harvard Law that's before the First Circuit in New England right now that would do basically the same thing. And that reform, along with the reform that the Center for American Progress is putting forward, would actually do the trick. It would get all the corporate dark money out and also keep individuals from overwhelming a race or politics generally with large individual contributions.
The Musk move to Texas isn't really to do with the politics of it. It's more
No.
to do with stock manipulation and how can I make a quick buck out of silly shareholders, isn't it?
Uh,
Oh, maybe you wouldn't characterize
that
it that
generally
way.
comports with my understanding of it. I don't know the details, but that's my understanding.
Oh, good. As long as I'm not totally befuddled about these things.
No. And I mean, one thing is worth noting is that Musk had a bunch of Texas LLCs and other organizations, and they spent a bunch of money in the 2024 election without disclosing any of it. And nobody knows how much money that was because none of that had to be disclosed. That is something that CAP's corporate power reset, this reform, will take care of.
Yeah, well, part of it is attitudes as well. I remember meeting the former British Foreign Secretary, Robin Cook, and his entourage, and they had just come back from meeting the State Department in Washington. And they said the State Department officials were sort of surprised and upset that the Brits drew a line between the large donation to Mascanosa and and United Fruit that resulted in restrictions on banana trading from the European Union countries in
Yeah.
favor of the in favor of and they say, oh no, that's not corruption. But President Clinton got a 500,000 donation the day before he signed this into effect. No connection. As you said, proving a direct connection, just a coincidence.
It's interesting in Buckley v. Vallejo, this U.S. Supreme Court was tasked with the question of like, hey, can you regulate this kind of expenditure, or would that hurt free speech? And they said, nope, can't regulate it, or that would hurt free speech. In Canada, in Harper v. Canada, the top court there was asked the same question pretty much, and the court said, you are required to have limits on expenditures because if you don't, large money will actually damage the free speech of everybody else. So it's interesting that they took the exact same question pretty much and came to exactly opposite answers on it, and that has made all the difference in Canadian and American politics. And Canada's got us on that one.
You think there might have been a touch of corporatist bias south of the border?
It was part of a concerted effort um, to get corporations more into American politics. Yeah.
Yeah. So where else? What else should we be looking at on this long march, long counter march through the institutions that you seem to
Sure.
have embarked on?
Well, there was a federal lawsuit filed last Friday in Hawaii challenging the new law there. It's called Act 11 now. It challenges it as if it were just a regular campaign finance law, just restricting this and banning this, and it's not. It is a corporation law that says this is what we're doing with our corporations. We are giving you fewer powers. That's it. And so that is the suit to keep an eye on. There'll probably be a lawsuit filed in Montana if it passes there, which we expect that it will. And hopefully this will get to the Supreme Court. And if it does, there are very good reasons that the Supreme Court, they will never like this. It does. The majority of the folks there are fully in agreement with the Citizens United decision and what resulted from it. But what they would have to do to overturn the Hawaii law or the Montana law would be immensely destructive to corporation law generally, but also the stability of corporations in America and a lot of the things like with federalism, that kind of thing that this court really cares about. So it's not one of these clean things where they can just strike something and it's gone. They would actually have to pull fundamental building blocks out of the American corporation
You
system.
seem
So
very confident that the Supreme Court would actually act on the law Whereas, there's strong signs lately that the Supreme Court will stand on its head and parade naked through the streets if that's what they're required to do, regardless of any legal precedents.
That is also my understanding of it. But what they don't do is they don't rule against their own interests. And they have an interest in a stable corporate world here in America. They have an interest in not dismantling corporation law. And what this sets up is a large clash of interests. It's not all on one side for them. They will be conflicted on it. And the question is, at the end of the day, I visualized it like this. This reform, the Hawaii law and the Montana law, is a spider, and they might have to. I'm asking them to eat that spider. They're never going to say, "Boy, I just can't wait to eat that spider. I'm going to enjoy that." Never get them to enjoy it. But the alternative is drinking a glass of battery acid that would have large and systemic damage, do large and systemic damage to a lot of other things that they care about. So they'll eat the spider if the only other choice is drinking the glass of battery acid. And what they would have to do to the American legal system, not because they're good judges or following the law or anything like that, what they would have to do to get at those laws would lead to very deep systemic damage that they don't want to do. So it's not that they would avoid it because they're good judges or it's a great reform or anything like that. It would conflict with their interests to overturn it.
From what you're saying about Hawaii and Montana, for example, it would appear that the counterblast is not going to be on a call to principle and defend free speech. It is disguising it as a sort of routine corporate, financial tidying up.
No, actually, what's interesting is these clauses that are sitting in all the states' laws that say, "Hey, you can pull back these powers. You can," they were put there by legislators in the 1800s who were afraid of corporate power, who were afraid that these entities that exist to accumulate capital and allocate it efficiently might accumulate too much capital, might accumulate too much power, and that's why they wrote these kind of escape valves into all the states' laws to do this. And so this is not a back door or anything like that. This is the front door of corporation law. This is exactly what these foundational pieces of corporation law exist to do, which is like, hey, we created these things. Now there's Frankenstein's monster out there wrecking the countryside. Let's haul them back in, retool them, send them back out. That's what this reform is doing, and it's nothing. There's nothing secret about it. There's nothing particularly new about it. The tools to do it have been sitting in the laws of the states for 1 or 2 centuries.
Well, longer. I wrote a book about charity law and corporations in Britain. 400 years of history involved and more. And that was building on the monasteries and the church.
There
So
you go.
it goes back. But look, Tom, this has been a fascinating discussion and hope it's signs that there are interesting times ahead as the alleged Confucian curse has it.
We live in interesting times, and there's more to come. So, but thank you
Okay.
so much for having me.
Thank you very much, Tom. Keep in touch with any other, you know, um, earth-shattering revelations.
We'll do. We'll do. All right,
So
take
this
care.
has been Ian Williams with the Foreign Press Association, our irregular podcast series Outside In, and I've been speaking to Tom Moore from the Center for American Progress, who's explaining the fascinating, almost subterranean moves on political power in this country. So, any other questions? I'm sure Tom would be pleased to answer them if you send them along. His details will be sent out with this. Thanks very much, Tom, and have a pleasant day. It's pleasant here anyway.
Thank you. You too.
Okay, great. Thanks a lot.
Phew.
That was no, I've discussed. I write about business as well, and I found that for most people, it's a real closed book.
Oh
Especially,
yeah.
might I add, for leftists, what they know about business and shareholding and corporate law could be written on the thin edge of a postage stamp.
Well, and for the right wing folks on the Supreme Court as well. I mean, they don't know anything about corporation law, and like I really think that I was kind of you look at the Citizens United decision, and it's like the nobody mentioned this idea of corporations getting their powers from the states, and it's like like it's just been set for 100 years and nobody's thought about it since then. It's like, and if any of those folks had been corporate law experts, they would have zeroed in on this, I think. Um, and yeah, so it's they're hopefully the courts will learn some about corporation law between now and when it goes to the Supreme Court. We'll see.
And let us hope they apply their learning.
Yeah, well, they'll do a lot of damage if they don't. So that'll be pointed out to them pretty clearly, I think.
Yes, so we don't want to be burnt in effigies, therefore we'll make lots of excuses when we have to do it.
Yeah, that might be it. Yeah.
Okay, look, thanks very much, Tom. And
Thank you. Such a pleasure.
all right, we'll send you the links and feel free. Broadcast it as much as you can. We like being broadcast, we're glory hunters. Okay. See you soon. Bye.